an act for the advancement of justice and more certain administration thereof. Whereas the common law is justly esteemed to be the birthright of English subjects, and ought to be regarded in this government as the safest rule of our conduct, and whereas acts of Parliament have been adjudged not to extend to these plantations, except when they are particularly named in the body of such acts, and forasmuch as some persons have been encouraged to transgress certain statutes against capital crimes and other enormities, because those statutes have not been hitherto fully extended to this government, and also that His Majesty's good subjects, the inhabitants thereof, have not yet been so happy as to obtain the royal confirmation of any law for the better establishment of their constitution and government, further preventing therefore any failure for the future. In that behalf, may it please the Governor that it may be enacted, by William Keith, Esquire, and with His Majesty's approbation and appointment, Lieutenant and Governor of the counties of Newcastle, Kent, and Sussex upon Delaware, and Province of Pennsylvania, by and with the advice and consent of the freemen of the said counties, in General Assembly met, and by the authority of the same, that all inquests and trials of high treason shall be according to due order and course of common law, observing the directions of the statute laws of Great Britain, relating to the trials, proceedings, and judgments in such cases. And be it further enacted, that the inquiries and trials of all petty treasons, misprisons of treasons, murders, manslaughters, homicides, and all other crimes and misprisons as by this act, or any other act of assembly of this government, are or shall be made capital, or felony of death, which have been or shall be done, committed, perpetrated, or happen within this government, shall be as by this act is directed. And be it further enacted by the authority aforesaid, that another statute made in the first year of the reign of King James I, chapter the 12th, entitled, An Act against Conjuration, Witchcraft, and Dealing with Evil and Wicked Spirits, shall be duly put in execution in this government, and of like force and effect, as if the same were here repeated and enacted. And be it further enacted by the authority aforesaid, that if any person or persons shall be so, as aforesaid, convict of burglary, which is a breaking and entering into the dwelling house of another in the night time, with an intent to kill some reasonable creature, or to commit some other felony within the same house, whether the felonious intent be executed or not, he or they so offending within this government, being convicted thereof, as aforesaid, shall suffer death without benefit of clergy, any law of this government to the contrary notwithstanding. And if any person or persons shall be so, as aforesaid, convicted of maliciously and voluntarily burning the dwelling house, barn, stable, or outhouse of another, having corn or hay therein, he or they so offending within this government shall suffer death, any law of this government to the contrary notwithstanding. And be it further enacted by the authority aforesaid, that if any person or persons shall receive, harbor, or conceal any of the said robbers or burglars, felons or thieves, or shall receive or buy any goods or chattels that shall be feloniously taken or stolen by any such robbers or burglars, felons or thieves, knowing the same to be stolen, and being so, as aforesaid, convicted of either of the said crimes, said offenses, if he or they pray to have the benefit of this act in lieu of clergy, judgment of death shall not be given against them upon such conviction, nor execution awarded upon any outlawry for such offense, but they shall be burnt in their hands in manner as herein after directed. And that the said justices before whom such offender or offenders shall be tried and convicted shall also at their discretion award and give judgment that such offender and offenders shall be committed to some house of correction or public workhouse within the county, hundred, or place, where such conviction shall be, there to remain and be kept without bail or main price for such time as such justices shall then judge and award, not less than 6 months and not exceeding 2 years, to be accounted from the time of such conviction, and an entry thereof shall be made of record pursuant to such judgment and award. And such offender and offenders so judged and awarded, there to remain and be kept in such house of correction or public workhouse, shall be there set at work and kept at hard labor, for and during such time as shall be so adjudged and awarded. And in case such person or persons shall refuse or neglect to work and labor as they ought to do, the master or keeper of such house of correction or public workhouse respectively is hereby required to give such persons such due correction as shall be fit and necessary in that behalf. And be it further enacted by the authority aforesaid, that where any murder or felony hath been here, hath been or hereafter shall be committed in one county of this government, and one or more persons shall be accessory or accessories to any such murder or felony in another county, that then an indictment found or taken against any such accessory or accessories, upon the circumstance of such matters before justices of the peace, or other justices or commissioners to inquire of felonies in the county where such offences of accessory or accessories in any manner have been, or shall be committed or done, shall be as good and effectual in law as if the said principal offence had been committed or done within the same county where the indictment against such accessory hath been or shall be found. And that every such accessory and other offenders above expressed shall answer upon their arraignments, and receive such trial, judgment, order, and execution, and suffer such forfeitures, pains, and penalties as is usual in other cases of felony, and as the statute made in the 2nd and 3rd year of King Edward VI, chapter the 24th, entitled An Act for the Trial of Murders and Felonies Committed in Several Counties, doth direct in such cases, which statute shall be observed in this government, and any law or usage to the contrary notwithstanding. And be it further enacted by the authority aforesaid, that every person who shall unlawfully and corruptly procure any witness to commit willful and corrupt perjury in any matter or cause depending in suit and variance in any of the courts of judicature within this government, or shall unlawfully and corruptly procure and suborn any witness to testify upon oath or affirmation in any matter, cause, or thing whatsoever, such offenders shall forfeit the sum of 40 pounds, one half thereof to the governor for the support of this government, and the other half to the party grieved, but for want of lands, goods, or chattels to satisfy the said 40 pounds, every such offender being convicted or attainted of perjury or subornation aforesaid, shall for his said offence suffer imprisonment by the space of 6 months, without bail, and stand on the pillory the space of 1 whole hour, in some market or public place where the offence was committed, and shall suffer all the other punishments, penalties, forfeitures, and disabilities which are inflicted upon such offenders by any law or statute of Great Britain, and that the statute made in the 5th year of Queen Elizabeth, chapter the 9th, entitled An Act for Punishment of Such Persons as shall procure or commit any wilful perjury, shall be observed in this government, and be duly put in execution, as well against those that shall falsify their affirmations as those who shall falsify their oaths, or be convicted of subornation of perjury. Provided always, and be it further enacted by the authority aforesaid, that no indictment, presentment, or inquisition, or any process whatsoever now depending in any court within this government for any of the crimes or offences mentioned in this act shall be discontinued, abated, or quashed for or by reason of this act, or anything therein contained, but that the judges and justices of the respective courts within this government shall proceed to hear, try, and determine the said offences and such indictments, presentments, and inquisitions mentioned to be committed against any act or acts of assembly of this government, as were in force at the time of finding, making, or taking the said indictments, presentments, and inquisitions, and thereupon to give judgment and award executions according to the directions of the said respective acts of assembly upon which the said indictments, presentments, or inquisitions are founded, as if the same act or acts of assembly were, by a special clause in this act, continued for that purpose, anything herein contained to the contrary notwithstanding. Signed by order of the House, Joseph England, Speaker.